We're going to hear some great stuff right now, and I'm really excited to hear it. So put on your seatbelt. Ladies and gentlemen, Mark Baird.
Can you guys hear me? Can you hear me now? Can you hear me now? My wife is laughing at me because I have my notes, and she laughs at me every time because she says you never use the notes. But if you'll forgive me, I need to use the notes tonight because there's a lot of stuff and I don't want to forget to say anything. So I want to start by I'm going to ask you some questions, and when you answer them, my purpose is not to embarrass anybody, to force an opinion out of anybody. I'm just curious as to what people think as we go through this. So the first question I'm going to ask, and you can answer just by raising your hand, yes or no, or shout, that's fine. The first question I want to ask is, are there any non-Christians in the room? And it's okay, it's not, I'm asking this for a very specific purpose. Okay, I don't see very many hands. But even if there are non-Christians in the room, I want the non-Christians to follow this as a legal argument. Now, I am a Christian. Jesus is my Lord. And so I have certain things that were given to me that were given to all citizens of this nation. And if you don't have faith in that, at least follow it as a lawyer would, because this is the legal argument that is the basis of our country. And that's very important to us because that's why the rules were invented, so that government would have to follow them. As John Adams said, liberty must at all hazards be supported. You have a right to it, derived from your maker. And even if that were not so, it was bought and purchased for you by your fathers with their ease, their estates, their treasure, and their blood. You have a basis for your rights given you by your Creator, by your Maker. Those rights are not rights that can be given away. They're not rights that can be sold. They're not rights you can give away. You can fail to exercise them, but they belong to you. They do not belong to government. They do not belong to government to change. They do not belong to government to enact policy over. They do not belong to government to denigrate those rights from a God-given gift placed in your heart at the moment of your creation to a mother may I permission slip at the whim of any elected official, any government official, any government body, or any government agency. Now, the first question I want to ask you is, if all that's true, what are we doing here right now? Because the problem with liberty is this: your liberty has a price. It's always had a price. Your fathers paid that price with their ease, their estates, their treasure, and their blood. Every generation has to pay that price. If you fail to pay the price, the next generation will have to pay twice. They'll have to pay for you, and they'll have to pay their own price. Because failure to pay that price is liberty lost. And that's why we're here today. We've already lost our liberty in the state of California. It's gone. It's gone because we didn't pay the price. And I'm not singling anybody out. I'm in this room too. It's gone because I failed to pay the price right along with you. That's why I'm here, because there is good news. We can get it back. We are the people mentioned in the Constitution. We have all the power. All just power is derived from the consent of the governed. We are the governed. We created this government, not the other way around. California was not a state filled with government waiting for you to show up so they could govern you. California was basically a land filled with all kinds of people: Native Americans, Spaniards, Russians, French. The British were out there trying to get money. Everybody was here trying to get money. Every fraud, crook, liar in the eastern United States came out to California to get money. Yeah, a lot of them are still here. I like that. I'm going to steal that. But the natural result of that is, after a fashion, people stand around and they say, look, you know, we need some kind of rules here because this just doesn't work. Everybody's shooting each other over their claim and stealing their stuff and stealing your life and your property. And in fact, several historians have told us that these rights that we have, these rights given us by our Creator, they predate government. And I can prove that. If you were alone and all you had was a skin that you wore, and you lived in the hole in the side of a mountain, would you not have the inherent inalienable right to protect your life? I mean, you're out there with saber-toothed tigers and bears and Lord knows what, and they have big teeth and claws, and you have none of those things. You don't have the ability. You can't outrun a bear. You can't outrun a saber-toothed tiger. You can't outrun a mountain lion. Heck, most of us can't outrun a badger. The way I'm going, I can't even outrun my old dog. So we have to form things in order to protect our lives, and those are weapons. And even Justice Ginsburg said the definition of a weapon is any instrument that can be borne. And the definition of borne is to carry on your person, in your clothing, in your pocket, for the purpose of confrontation in the event of conflict. So you have the inalienable God-given right to protect your life with any instrument you choose that you carry upon your person in public for that purpose. Because how would it have worked if this caveman lived in a hole in the ground on the side of the Himalayas or wherever he lived, but he just knew that his weapon was only able to be used when he was in the hole. So when he left the hole, he left the club in there. And then he walked out into the world to do his business. That is obviously not what the framers intended with the guarantee to your already possessed God-given right. Obviously not. They could not have thought that, and they did not think that, and I can prove that too. On April the 18th, 1775, 70 men under the command of Captain John Parker and under the tutelage of Pastor Jonas Clark, and the night before, Sam Adams and John Hancock were sitting around with Jonas Clark in his house, and Hancock was scared. I mean, they knew that 70 regular soldiers, now they didn't say British, they were British. They weren't Americans. These guys were subjects of the King of England. They were not sovereign citizens like you're supposed to be. They were subject to the rules and laws of the king, even if that was their death. Because subjects don't have a say in things. They are subject to whatever rules their ruler wants to subject them to. They do, however, have inalienable God-given rights, and one of those, the very first among those, is the right to life and the protection of that life. Without that, if you can't protect your life, what's your life worth if somebody can come and take it anytime they want to? So John Hancock is worried, and he asked Jonas Clark, he said, hey, you know, and I'm going to paraphrase, he said, hey man, are we going to be okay here? 700 of my government's best soldiers are on their way here to kill me and kill John here and take your powder and your shot. Why didn't I say guns right then? Because the guns belong to the individuals. The powder and shot were the only things stored in the magazine. Guns were not property of the community. Guns were individual property prior to the Constitution. So these British regulars show up, regular troops, the most powerful military on earth, and across the green stand 70 American militiamen. What made them militia? The fact that they showed up at church every Sunday and they had training. So Jonas Clark looks back at John Hancock and he says, there's no need to fear. I have been training these men for this moment all their lives. Think about that. They didn't have a mother may I slip from government. They didn't have a government-issued firearm. The government didn't say you can have a squirrel gun, but you can't have a .54 musket. The government didn't say no rifled barrels. Oh boy, those are unfair because they're too accurate. The government didn't say you can only have a knife that's 2 inches long. They didn't say any of that stuff because they had not the right to say that. These men had the inalienable right to defend themselves, their families, their community, their colony, and their nation. And that right was given them by God Almighty Himself. So are we asking the question today, is government taking the place of God because they pretend that your rights are theirs to give and take? That is the question we're asking. Is government going to take the place of God in your life? Or are you going to do something about it? And we can do something about it. So I want to ask just a few questions. First of all, is your family for sale? Is your honor or integrity for sale? Is your dignity for sale? Well, not unless you're on Judge Judy. Then your dignity is for sale, and it's pretty cheap too. Is the safety of your family and your community for sale? Then why is it the state of California came and they took your right to carry a firearm and they didn't give you anything for it? They didn't ask your permission. They came and they took it. They took it first on May the 2nd of 1967 because a bunch of Black Panthers, and you know, I got my opinion of the Black Panthers. I was old enough to know what was going on. But these guys had a little demonstration on the steps of the Capitol building on May the 2nd, and they took a bunch of old pistols and shotguns and stuff, and they were marching around the Capitol. Nobody got shot, nobody got threatened. It was kind of a stupid political demonstration, but it was their right. And here's the problem with the constitutional republic. Even the minority has rights. That's why we're not a democracy. Because the minority has the right to do everything you have the right to do, whether you like it or not. You have to die to protect that right. So they demonstrated with guns, they went inside the Capitol, they scared the heck out of all the people in there, and then when the state police told them to, they all left. No one got shot, no one got threatened. I don't even know if the guns were loaded, they don't either. Then after they got back to Oakland, every single one of them was charged with a felony. What felony, you ask yourself? It was legal to carry the gun, it was legal to carry it loaded. Conspiracy. What was a conspiracy about? Well, it was just conspiracy. You conspired to do something that we, who sit in judgment of you and your rights and your liberty and your freedom, don't like. And you're guilty. And it's a felony. And you know what that means? They all lost their gun rights. Why? Over some really vague term called conspiracy. Heck, you know what? If the state of California, if the DOJ was back there in the corner, they could charge all of us with conspiracy. And they'd have no less ground to make that charge stick than they did against those lunatic Black Panthers. So, needless to say, after that, about a month later, the Oakland Assemblymen got together with one of the big gun organizations, and I'm not here to point fingers, and I'm an NRA member myself, and we have to, and I urge all of you, if you're not NRA members, join. I don't agree with the NRA every day, but they are the big gorilla in the room when it comes to lobbying, and we need that. We need that collective power. But they got with some of the gun orgs, and they wrote legislation, and they banned the open carry of a loaded weapon in California. Now, unfortunately, when you strip a minority of the rights, you have to strip everybody. You lost your right to open carry of a loaded weapon in California in July of 1967 because the state was mad at 20 people that came from Oakland and had a demonstration. Is that constitutional republic? I think not. I think that's tyranny. And I think it's despotism. And we allowed it, and nobody said a word, and nobody filed a case against it. Now, I was just a kid. But I did know. And then time goes by and people forget that they once were able to do something they're now not able to do, and then it's lost to memory. Then again, you had the right to open carry an unloaded weapon as late as January 1st of 2012 for pistols and January 1st of 2013 for long guns. And we used to do it all the time on the ranch. You strap your gun on, you had your magazine on the other hip, and you know, it wasn't great, it wasn't perfect, it wasn't a right, but at least you had the thing if you needed it. And then in 2012, a state assemblyman at the time, Anthony Portantino, whose sole claim to fame, this catapulted him into the national stage in California politics, he was the art director on the Grizzly Adams TV show. And that made him famous, and he won in his district in Glendale, and then he made the statement on the assembly floor, "This isn't the Old West, and you don't need a gun to go buy a cheeseburger." And then he introduced the bill to ban the open carry of an unloaded pistol, and all of his Democratic buddies passed that. And you then lost the right to carry an unloaded pistol. And then 1 year later, he thought, well, that was pretty good. So he got another bill passed, and you lost the right to carry an unloaded long gun. So the open carry of any form of operable weapon is now against the law in California. That is the Second Amendment, right? So the state of California banned the Second Amendment in 2012 and 2013, and nobody said a word. Not me, not anybody. We just let the most important liberty we had die on that date, and we never made a move to stop it. So I want to ask a couple more questions. Do you trust a government that doesn't trust you with the same tools they have? Gosh, that was a tough one. I want to ask you also, what is the legitimate role of government, and what is the price of liberty? Because that's the price we didn't pay. Well, the price of liberty is eternal vigilance. That's the price we pay for liberty. But with eternal vigilance comes the responsibility of action when we see something go wrong. What good does it do you to see something and not do anything about it? None. So we have failed in that responsibility, and we're going to fix that starting tonight. Now, we want to do that for many reasons. First of all, I owe my son a duty. And it's the only duty that I'm given in the Constitution of the United States. It's the only one as a citizen I can fulfill. And that is to secure the blessings of liberty for my posterity. That's my job. How do I know that? How can I prove that? And by the way, don't take anything I say at face value. Please do some research, look it up. It doesn't do any good for me to yammer at you and you to walk out of here and just say, oh wow, that was great yammering. Look this up and solidify it in your own mind. It's easy. These documents are all over the place. So if we have the responsibility to secure liberty for our posterity, and we fail to do that, how can we rectify that situation? Well, we have all the power. That's how. We're the people. Article 2, Section 1 of the California Constitution says that whenever government fails to serve the people, they have the right and the responsibility to alter or reform government whenever the public good demands. It doesn't say at the next referendum. It doesn't say elect a better dude. It says whenever government fails to serve you, you have the right to alter or reform government. Guess what? The Declaration of Independence also says that. I mean, is the Constitution our founding document? No, it's not. The Constitution's our second try. Because the Constitution says something funny. We, the people of the United States, in order to form a more perfect union. Well, what an odd thing to say. Why wouldn't it just say, we the people of the United States in order to form a perfect union? It says more perfect, because it wasn't our first try. The Articles of Confederation were our first try. They didn't work. We had 10 presidents of the United States before the Constitution. But in that process, we figured out where we went wrong, and I believe the men who authored the Constitution were divinely inspired. And I believe that with all my heart. And I'll go to my grave defending that document from any usurper. And I don't care what he calls himself, senator, congressman, mayor, I don't care who that is. They will not cross that line in the sand with me, ever. Well, I have the power to do anything about it. And I have been all over the world, by the way. I've flown for a military contract airline for 28 years into 6 conflicts for the United States government. And I want to tell you something. The difference between this nation and most of the world is this. In most of the world, particularly the undeveloped world, you can be walking down the street with a lot of other people, and someone would pick up a brick and kill you for a nickel that you have in your pocket, and no one would even slow down while he was doing it. That's the difference between the United States of America and most of the undeveloped world. And I've seen it with my own eyes. It's true. And we will become like that if we allow it. We cannot allow those things to happen. So Thomas Paine said, "It follows as a natural result and a logical result that the governmental exercise of any power not authorized by the Constitution, the exercise of any power not authorized by the Constitution is an assumed power, and it is therefore illegal." This is really an important point. The Constitution was not intended to protect you from all the ills of the world. It wasn't. It was not intended, the Constitution was not intended to be the vehicle that stands between you and all evil of unsafe baby carriages and dirty air and dirty water and cars that don't get enough mileage and plastic straws and whether pigs and fish want to get married and where they should live after they do it and all of those things. The Constitution was meant to protect you from one thing and one thing only, and that is human nature. And human nature never changes. It is the nature of human beings who gain power to get more power. And in gaining that power, they strip you of your liberty. And the Second Amendment is all that stands between us and that fact, because in most of the known world, they do not have the right to keep and bear arms. And government can do anything it wants to its people. And if you doubt that, look at Venezuela, look at Mexico, look at, I don't care where you point your finger at the map, Rwanda, South Sudan, Eritrea, Libya, I could go on and on and on. Those are just the places where I've seen it happen. That will not happen here if we stand. And it matters. It does matter. Because we owe it to future generations to hand them a country that is essentially in the same shape as the one that we got. That's our duty. Let's not fail. How can we do that? California has already taken our Second Amendment rights. They're gone. That's a fact. We can exercise those rights anyway, and I'm okay with that, and I do it every day on my ranch and pretty much wherever I go, but you can end up in jail for it. So what we need to do is we need to fix this, and we need to do it in a way that involves as little jail time, bloodshed, turmoil, chaos as possible. And that's through the legal process, and we can do it. Because the state of California has a big problem right now. George Young walked into court one day, or he walked into the Hawaii Police Department one day, and he asked the chief of police, he says, "I want a permit to carry a gun. Some guys are after me." And he says, "Well, what kind of permit do you want?" And George says, "I don't care, just give me, I just want to be able to carry a gun." So the guy says, "Well, here, fill out these papers for a concealed carry permit." What is a permit? It's permission. It's a mother may I slip from the government. "Mother, may I please have a cookie?" No. You can have a cookie, but you can only have one this big. You have to leave it locked up in the garage, in a safe, disassembled, by the way. The cookie can't be together. And then when you're at home, and only when you feel like your life is threatened, you can get the cookie out, put all the pieces together, and take a bite. That's what a permission slip is. Because anything the government gives you permission for, the government can take that permission away. So George goes and he gets the concealed carry permit, and then after that, the chief of police for the county of Hawaii, which is the entire island, the big island of Hawaii, he says, "Well, you can't have that permit." And George said, "Well, why not?" And he says, "Because we've never ever given one of those out. And we're not going to start with you." So he says, "Okay, well, give me the other kind. What's the other kind?" And the chief says, "Open carry, exposed." "Well, give me one of those then." And he says, "Are you a police officer?" George says, "No." He says, "Are you a security guard?" George says, "No." He says, "Well, we're not giving you one of those either." Well, fortunately for us, thank God for George, because he sued him. And he went through the trial court. You know what the trial court said? "Well, the state is sovereign over you." Wow, huh? I mean, let that sink in for a second. You don't have rights equal to the state. The state has the right to deny you anything they want to or regulate anything they want to, because in the balanced interest of the populace, we have the right to say, you don't need the right to have that gun. It's more important for us to keep people safe, and if we think people feel safer, then you can't have the gun. That's how they do that. So George went to the Ninth Circuit Court, and God bless Judge O'Scanlan, because George got Judge O'Scanlan. Now, Judge O'Scanlan was the very guy who sat on the Peruta v. San Diego case. And I don't know if you guys remember that, but Peruta v. San Diego was the NRA and Second Amendment Foundation and Cal Guns and all the big gun organizations, because quite frankly, the big gun organizations don't support open carry. They never have. That worm is turning, though. More good news. The good news keeps coming here. So in Peruta v. San Diego, a couple of guys wanted concealed carry permits. The government said no. They sued. It got all the way to the Ninth Circuit. They drew Judge O'Scanlan. And Judge O'Scanlan said, well, in California, you can't carry a gun open because it's against the law. So therefore, you have to give these guys a concealed carry permit. But even Judge O'Scanlan kind of didn't get it, because you have a right to something. You shouldn't have to ask anybody for that, right? But anyway, they did, and O'Scanlan says you have to give these guys a permit. Well, he ruled. That was the law. Boy, the state of California freaked out, and so did all the judges in the Ninth Circuit. Holy moly, we just can't have the government having to give these permits out to anybody that wants one. So they formed an in-bank panel, and it was one judge. They call that sua sponte. One judge said, I want to rehear this case, and I want the whole court to rehear it. So they got 19 judges or whatever it was, and they reheard the case. Well, guess what they said? No. Concealed carry, and I gotta say, I don't agree with the Ninth Circuit Court very often, but they're right about this one. Concealed carry is not a right. It falls wholly outside the Second Amendment. States can regulate it, states can ban it, states can do whatever they want with it. You do not have the right to hide a gun on you. You never did. And I gotta say, since 1791, there has never been a court case that affirmed the right to conceal carry a weapon. Never. And the Second Amendment Foundation and the NRA has had 8 or 10 of these cases, and they lost every single one of them because concealed carry is not a right. Well, that brings us to the really good part. There's only 2 ways to carry the darn gun. Either hide it or don't. Concealed carry is not a right. Well, what does that mean? It means open carry is, because no state may deny a citizen his enumerated rights. D.C. versus Heller, City of Chicago versus McDonald, Cruikshank versus United States. Open carry is the core right of the Second Amendment, and in fact, in Cruikshank v. United States, it says, open carry is a core right of the Second Amendment, and it is wholly undependent upon that document because it predates the Constitution. And it is also unconnected with malicious service. Let's whip back to April 18th of 1776 now, or 1775, I'm sorry. Where did those guys get the guns that they walked down to the green with? Off the mantle, behind the door, out of the closet. They were their guns. They weren't the government's guns. And they were any gun those guys had. In fact, their service in the militia was presupposed that they owned certain things already. They had to own the gun, 25 rounds of ammunition, a powder horn, a possibles bag, and several other things. So you had to have that stuff or you couldn't even join the militia. Well, that tells me something. The Second Amendment predates the militia, predates the Constitution. It predates everything. It predates government. That is your right to life and protect that life. So now we come down the pike and we see that certain Supreme Court cases, Heller versus D.C., open carry is the core right of the Second Amendment. And concealed carry is not. Open carry is the core right, according to Heller, so that it prevents unmanly and secret assassinations. In other words, if you wear your gun on the outside of your pants, then everybody can see it and everybody knows what your intentions are and everybody can see whether you have something in mind or not. That's always been the way in this country, always. The only exceptions for concealed carry were people who were on a journey because the supposition was you're wearing lots of clothes, it's cold, you're on a train, you stuff the gun in your pocket. That was okay. But it was never considered okay for you to hide your gun when you were walking around, never. So, Peruta is right. The in-bank reversal of the Peruta case was correct. And the Supreme Court saw it because they refused to hear that case. So the NRA, the Second Amendment Foundation, Calgun, CRPA, all of those guys that wrote amicus in Peruta, all wrong. So let's put that aside now. Concealed carry is not a right, open carry is. Here comes George Young. He goes through the federal court. The federal court says, no, George, you're nuts. States can do whatever they want to you. He appeals. He draws Judge O'Scanlan. So here's Judge O'Scanlan, one of the true patriots and conservatives on the Ninth Circuit Court, and God bless that guy. And he says, well, okay, I'll give this another shot. If concealed carry isn't the right, then open carry must be, because states can't ban an enumerated right. So he gives George Young, he says, open carry is the core right of the Second Amendment, and it applies outside the home. In other words, it applies to public places. In fact, Ruth Bader Ginsburg in Satano versus Massachusetts says the state may not debar a person from carrying arms, because if they did, then your right to defense would be the property of the state, and states are often more interested in disarming you than they are in keeping you safe. Ruth Bader Ginsburg said that. She's one of the craziest judges on the court, and she knows it. In fact, in Satano versus Massachusetts, they said you cannot prevent, states may not prevent a person from walking about armed. Wow, I mean, that's huge. And still nothing in California, nothing. Here we are with no right. So Young goes to court, O'Scanlan rules for him. That's the Ninth Circuit, it's law. How come we're not packing our gun? Because California won't observe the law unless it suits them. Now, we were talking earlier, and I was saying, what if the Young case had to do with plastic straws and ruining the environment? Well, California would be all over that. Oh, well, look, the Ninth Circuit says plastic straws are no good. No more plastic straws, everybody. But because it's your right that's in question, they are hiding under the table. Now, here's a problem for us. You cannot compel a state to stop enforcing an unconstitutional law unless you sue them. So here we're coming to the crux of the matter. So Young goes through. Now, people are panicked. The state of California is panicked. Oh my God. The people in California might just start walking around with guns again. And remember, 6 years ago, we could walk around with a gun. But that was 6 years ago, and it's a more dangerous world now. We can't have that, can we? So the state of California and the state of Hawaii have appealed to the Ninth Circuit, and they are asking for Young versus Hawaii to be reheard in bank. In bank means by all the judges. If the court accepts that case to be reheard in bank, then what I'm talking about here tonight will go away. It won't happen. But I don't think they will. And the reason I don't think they will is this. It's pretty simple. First of all, think about the gun grabbers on the court and their mentality. What if they rehear Young versus Hawaii and they reverse it? And they say, you don't have the right to carry a loaded weapon, exposed. They just got done saying you don't have the right to carry a concealed weapon. So now what the court would say in bank, you don't have a Second Amendment. That's going to go to the Supreme Court for sure. And guess who wrote the opinion in Heller versus D.C.? Kavanaugh. And George Young's case was modeled on Kavanaugh's opinion. It's almost identical. It's almost word for word. So in the mind of the gun grabbers, I'll put myself in one of the gun grabbers' places, and I'll say to myself, gosh, if we reverse Young and it goes to the Supreme Court, there will be permit-less open carry of an exposed and loaded weapon in all 50 states of the United States. But, amen. Amen to that. But if we fail to rehear Young, it's already permitted in about 8 or 9 states of the Ninth Circuit, so all we'd have to lose is maybe California and maybe Hawaii, quite frankly. So if we do nothing on Young, and the governments of Hawaii and California hide under the desk, then nothing really changes. I mean, Young is the law. We're not packing our pistols on the outside of our shirt. So what does California have to lose in this deal? And the answer to that is nothing. That's the truth, unless we act. And here's what I propose to do. I propose to get a restraining order against the state of California to bar them from enforcing unconstitutional laws, and those laws are 25-850, the carry of a loaded weapon, exposed carry of a loaded weapon, PC 26-350, the exposed carry of an unloaded weapon, and 26-400, the exposed carry of a weapon that's not a pistol, in other words, a long gun. So if I go into court and I say, Young versus Hawaii is the rules, that's your Ninth Circuit, they have jurisdiction over you, and I want the court to tell you it is unconstitutional for you to continue to enforce laws 26-850, 26-350, and 26-400 that are unconstitutional, that are now unconstitutional. And California just says, well, yeah, but we're not doing that. Well, there's also a Ninth Circuit case that's pretty interesting. It's called Chambers versus United States. And that case says that any opinion that issues in the Ninth Circuit Court of Appeals is binding on every single judge in the circuit, and that includes trial courts, especially trial courts, even if the mandate was never published. And that was a Ninth Circuit in-bank case that was never appealed. That is the law. So Young versus Hawaii is the law right now. California's hiding. Chambers versus U.S. says that's the law and it applies to you judges. And we walk into a federal court and say, Young is the law, and Chambers says you have to obey it. I want a temporary restraining order against the state of California to force them to stop enforcing the unconstitutional penal codes that have taken my Second Amendment rights. And then after the temporary restraining order expires in 2 weeks, have the lawyer come back and make it a temporary or a permanent injunction, as whatever the case may be. Now, the judge might say, well, what if Young is reheard? Well, what if it is? It hasn't been yet, and it hasn't been accepted for rehearing yet, and it may never be accepted for rehearing because the court cannot deny an enumerated right, and they've already said concealed carry is not a right. So this court would have to reverse itself in bank in order to make any of that stuff happen. Now, the state of California has a really weird legal theory that they're advancing in order to do this. And that is that states may regulate, and this is the first time I ever heard this, public carry. They're not talking about concealed or open. The fact that you want to carry in public, no matter how that is, states can regulate that or ban it or make you ask permission for it. If we allow that, shame on every single gun-owning citizen of the state of California, and by all reports there are about 7 million of us. If we don't stand up and act now, we will lose the opportunity and lose the right to act in the future. Because a liberty unexercised is a liberty lost. So I'm here tonight to ask all of you for your help. My wife and I have already written a fairly sizable check to the attorney, but we're not rich people. And this isn't an expensive case as federal cases go. Not expensive. I'm going to say $25,000. That's really expensive, but not as courts go. And I need help to finish this deal. And we hope that it'll go fairly quickly. It's just a temporary restraining order and an injunction. I have to write a case. There's no depositions. There really aren't any witnesses. Young versus Hawaii, Chambers versus U.S. And let me emphasize something. How many of you think the police have the duty to protect you? Raise your hand. Pretty educated bunch here. They do not. And here's the sad part. They will suffer no liability for failing to protect you. California Government Code Section 821, 845, and 846 tell us that the government of California has no duty to protect a specific individual from crime or violence or anything else for that matter. And further, you may not sue any state employee if he fails to protect you, even when he knew you were under direct threat. You can't sue him if he arrested a dangerous person and let that person go and then that person came and harmed you. You can't sue him if you made repeated complaints to the police department and they knew you were under direct and imminent threat and you were in fact harmed and you sued them, you would lose. And there are many, many Supreme Court cases that tell me that. Warren versus D.C. 3 women in an apartment, brutalized over a period of hours and hours after repeated calls to 911. What did the Supreme Court say to them? The government has no duty to protect the individual. Duchesne versus Winnebago County, a gal who called because her husband was threatening to kill their children after a nasty divorce. The police advised her to move. We can't help you, move. The children were murdered right in front of her. She sued the police department because she had a protective order. She had a restraining order. The guy violated it time and time again. She said, save me. They said, we can't help you. Supreme Court agreed. The government has no duty to protect you, and they will suffer no liability for failing to protect you. And Mrs. Duchesne even claimed a special relationship. I have a protective order. And they said, no. The only special relationship under which a police officer has to protect you is if you are a prisoner and you've been physically deprived of your liberty. That's true. If I, as a police officer, take your liberty away from you physically with handcuffs, it is now my responsibility to protect you because I have deprived you of the ability to do it yourself. What has the state of California done to you? Done the same thing. They just didn't use the handcuffs yet. They still have them though. So Riss versus New York, same thing. A guy threw a bucket of lye in the gal's face. She called the police 100 times, and they said, why don't you, in fact, the police in the Riss versus New York case, they even told her, stop being nasty to the guy. Maybe he'll be nicer to you. She was permanently blinded and disfigured, sued the government, and they said the government has no duty to protect you. Again and again and again and again. In Citano versus Massachusetts, this was a great case because the gal had a really nasty boyfriend. One day at her work, and this is important for us, one day at her work she whips out a stun gun because he was coming to beat the tar out of her again, and she says, I will shock you to within an inch of your life if you don't leave me alone. The guy got scared and ran away. But one of her coworkers saw her with a stun gun and called the police, and they arrested her and charged her with a felony. Because in Massachusetts, you cannot carry an exposed weapon, or excuse me, in Illinois. I'm sorry, no, it was Massachusetts. You can't carry an exposed weapon. And she won, and that was big for us. States cannot debar a citizen from bearing arms for their own defense, because the state has more of an interest in disarming you than it does in keeping you safe. That's it, folks. We can win this. We must win this. We can start restoring liberty in California with this action alone. And if we can do this, we can do more. If you can help us do this, we can turn to the rest of California and say, if you'd like the rest of your liberty back, help us. Get off your lazy backside and show up and start helping. And that's my goal. Let's restore liberty here. You know, I'll close with this. It was Christmas, I think, 1776. And George Washington, it was Christmas Day, and he was sitting in his office. And he was writing furiously on these scraps of paper, and then he'd tear off and write something else. And Dr. Joseph Warren walked in the office to talk to old George. They were kind of pals, a little bit. And one of the scraps fell on the ground. And George and Doc Warren picked it up. He said, what is this? And George says, it's the password for the attack tonight. And Dr. Warren picks that up, and he reads it. And it says, liberty or death. Then those guys walked 7 miles, most of them barefoot, crossed a river choked with ice, walked 7 miles back to Trenton, and surprised one of the most well-trained, and believe me, the story is the Hessians were drunk. They were not drunk. They were very devout Protestants. They did not drink. Colonel Rahl was not drunk. They were asleep. And in fact, the only thing, God's intervention in Georgia's success, was that the weather was so nasty horrible that the German colonel thought no sane man would ever attack in this kind of weather. And he literally, for his day, he was right. So he just went to bed and they didn't set up outposts. And those men won the day. Not because they were better than us, right? I mean, are we less than them? Are we dumber than they were? Are we less courageous than they are? Are we less courageous than John Parker and his men standing there staring at 700 of his own government's troops across the green? Do we not have that stuff in us? I mean, Patrick Henry asked in the Virginia Burgesses, he said, what would gentlemen have? What would you have? In a perfect world, and I'm asking you, what is it you want? And the guys there that day said, well, we want peace. We just want peace. And he said, well, there is no peace. Aren't you listening? Aren't you paying attention? Our comrades are in war now. He said, is life so sweet or peace so dear to be purchased at the price of slavery and chains? Almighty God forbid it, for I know not what course others may take, but as for me, give me liberty or give me death. I'm asking you tonight, is there a line in the sand for you, and what is it? Thank you very much. Thank you.